evening. I'm Ina Winston, and welcome to this edition of Immigration Issues. It's my pleasure to do immigration work at the Chicago Legal Clinic, and most of you are familiar with the clinic. The clinic, as you know, was established in the 1980s by two then DePaul Law School classmates, Ed Grossman and then Father Paprocki, now Bishop Paprocki. And the clinic has grown. We now handle many different types of law, ranging from bankruptcy to immigration to housing law to family law, all kinds of matters that are of importance to ordinary working people. We're now in a new phase of our existence. Our prior executive director, Ed Grossman, our founder and prior executive director, has turned the organization over, and we have a new executive director, Adam Salzman, and we are now in a unique position. Right now, we've consolidated our offices so that we're downtown, and we are planning a move to the inner Cook County suburbs. So you should stay tuned for more information about this wonderful and unique organization that does so much good for so many people. And it's really my pleasure to work for this organization. I have wonderful colleagues and great, interesting clients who are resourceful and enterprising and often very courageous immigrants. So it's my pleasure. I'd like to give you a little update on some of the many things that have been happening in the immigration world, and then I would like to turn the show over to Drew Curl, who is the supervisor of the criminal records section at the clinic, which deals with return to work issues and many other important issues to people who have had interaction with the criminal system. So let's take a look at some of the things that have happened in the immigration world. I'd also like to remind you that this is an interactive show, and we have somebody here who's be glad to answer your phone calls if you have questions. And we'll put you on the air. Okay, so for those people who have temporary protected status, this week brought decent news. While the government has been threatening to shut down temporary protected status for a very long time, temporary protected status, for those of you who don't know, allows people who are in the United States, who are from countries that have experienced war or natural disasters or other unusual disruptions, to if the country is designated as a temporary protected country, the person can stay in the United States and gets a work permit. So the government wanted to end this program. For example, many of the people who came were from Honduras, and they came when Hurricane Mitch hit Honduras and caused widespread devastation. Many of these people now have been here since the 1990s. They have families, they have homes, they are hardworking people. So naturally, the possibility of shutting off temporary protected status for people who have established lives here is a nightmare. And other countries that have been designated were El Salvador, Haiti, Nicaragua, Sudan, and Nepal. And as a result of the threats to shut down temporary protected status, there were lawsuits to keep it going. And the lawsuits basically said that the government violated the Administrative Procedures Act by not following its long-established policy of looking not only at the original conditions that led to the grant of temporary protected status, but by looking at the actual current conditions. Yes, perhaps the devastation from Hurricane Mitch is no longer the issue, but Honduras has an extraordinary murder rate, and it would be a dreadful disaster to suddenly deport people who have been working here and have lives to Honduras. So lawsuits were filed both in California and in New York, and as a result of those lawsuits, there is an injunction right now in effect against the termination of the temporary protected status. The case in the Ninth Circuit, which is California, has gone on appeal. So at some point we should have a definitive decision about what happens with temporary protected status. Temporary protected status is actually a hard case to deal with because there is a statutory section which says there is no judicial review of a determination by the Secretary of Homeland Security with respect to the designation or termination or extension of the designation of a foreign state as being eligible for protected status. So you have the statute to work around. So to get an injunction in the face of that statute required extraordinary skill. And the argument is that this is not a matter of the designation of the state as being eligible originally. This is a matter of the procedure being followed to terminate the status. And there's also a constitutional issue. The plaintiffs in these cases have argued that there is expressed animus by the government against non-white, non-European immigrants. What's the outcome? The outcome right now is that the current expiration date for temporary protected status for these 6 countries was January 2nd of 2020. In the case of El Salvador, Haiti, Nicaragua, and Sudan. And the new expiration date is January 4th of 2021. That same January 4th, 2021 date has also been extended to Honduras and Nepal. So that's good news for the many hardworking immigrants who are on temporary protected status, have jobs, have families, have homes, have U.S. citizen children. Okay, so that's a bit of good news. Not such good news are partial good news and partial bad news. The public charge issues. We've talked about public charge before on this show, and you know that it's a totality of the circumstances. Well, the public charge rules have been put on hold by virtue of an injunction in the context of adjustment. However, in the context of consular processing, the reality is that these public charge totality of the circumstance evaluations, which really means it's in the discretion of the particular officer, are still being used. And in addition, people who are consular processing have to show that they have health insurance. It's really hard for a person who's not here to get health insurance. They're not here, they have no social security number, and the health insurance has to take effect within 30 days of their arrival. So this is a real challenge for practitioners who have people coming in on consular processing who are subject to this rule. And I've talked at length earlier about the public charge rules and how disastrous they are for the country, not just for the immigrants. I mean, we're a country of immigrants, and immigrants are the most entrepreneurial people. And if we want to grow our GDP, we need people. We need more people. So it's very disturbing to have these public charge rules. Other news, the DACA arguments. The DACA arguments were before the Supreme Court on the 12th of November, very recently. It didn't sound like those arguments went so well from the questioning, but it's really hard to know what the outcome's going to be when you have to consider the actual reality, which is that there's 800,000 people, young people, on DACA, and the government immediately went to slam these people after saying that they were beautiful young people and nobody wanted to deport them. Then the government said, oh, they're not angels, they're criminals. That's a flat-out lie, because if they're criminals, they don't have DACA. They can't renew their DACA. So the argument in the DACA case, again, is one of whether the Administrative Procedure Act was followed, whether when you are changing a long-standing policy, you're doing it in accordance with a announced rational basis. And the announced basis wasn't so rational. The announced basis was that a suit in Texas dealing with DAPA was decided against the government, and that this rationale applied to DACA, but they were two totally different remedies. And then the government said, well, we don't want to run the risk of litigation. But as the district court said in the DACA case, well, you just swapped one lawsuit for the other. One lawsuit by people challenging the existence of DACA for a lawsuit by people challenging its termination. So how did you minimize the risk of litigation? You didn't. Notwithstanding that, it kind of looks from the questioning that the outlook is, well, it's a policy, it was established by a president, it can be withdrawn by the president. We don't really know till we see the decision. Now, I would like to turn to our very special guest, Drew Curl. Drew Curl is an experienced attorney, and as I say, he is the supervisor of the Criminal Records Section. Why don't you tell us a little bit about your background and what your section does?
Thanks, Ina. So, as she said, I supervise the Chicago Legal Clinic's criminal records program, and so that means that I deal primarily with expungement and sealing cases for people that have past arrest records, primarily here in the city of Chicago, but we're also branching out into other Cook County suburban districts. So the main things that I do as part of that are in-house expungement and sealing cases. So that's anyone who is interested in starting a new expungement or sealing case. They can call us up, and for a flat fee on a sliding scale, we can do that case, at least potentially. And then also I do a help desk-based service where we assist all the pro se litigants that don't have an attorney already, that show up with an expungement or sealing case in the courthouse on Thursdays.
Which courthouses?
That's the 26th in California criminal courthouse, the Layton criminal courthouse.
Well, let me ask a kind of basic question. What is expungement? What is sealing? What is required for each of these? And what's the benefit to the person?
Yeah, that's a good place to start. So expungement and sealing are two different ways to get your criminal record hidden from public view. The difference between the two is expungement means law enforcement will destroy their copies of your criminal records, and the clerk will put them under seal so that no one can see them unless you request to see them yourself. Sealing, by contrast, law enforcement retains their copies of the records, but they're sealed from public view. So only law enforcement will see it if you were to get arrested again, or you applied to work in a law enforcement related job.
If a person is, I know that in the immigration context, expunged or not, you need to present your criminal records. It's not just wiped clean. The government wants to see whether you have committed crimes or even just been charged with crimes. What do you do in that circumstance?
So that's an important point. One of the things that is sometimes a misconception is people think that they can expunge or seal their record to help their immigration case. But as you just said, if you're applying for immigration status, you still need to provide those records. So the best thing to do if you haven't filed yet is to retain copies of your certified dispositions of any cases that you might have.
Do you know what a certified disposition is?
So that is your official clerk's record of what your criminal case was. So it says what you were charged with, what happened in the case, and ultimately what the outcome was, so if you were found guilty or not.
And it has a raised seal of the circuit court clerk saying, this is the kosher record, the real deal.
So the certified part of it means that it's been stamped by the clerk with a special stamp saying that this is the official copy. Now, if you maybe have already done a sealing and expungement case and don't have those anymore, what you'd want to do is what's called a motion to access records, which you would file in the same courthouse you did the expungement or sealing case in, and that will give you an order which you can then take to the clerk's office to get that certified record, even though it's been sealed or expunged from public view, so that ordinarily no one would be able to access it. But with this order, you can show it to the clerk and they'll be able to pull it up for you.
Well, let's take us through a simple case. I'm a young person, and when I was in my early 20s, I was a little wild, and I did commit some crimes that I'm not proud of, and I'm rehabilitated, and I'm just a responsible, normal person, and I want to get a good job. I don't want to get a job in law enforcement. I just want a job, and I want to be able to, when I apply for an apartment, I don't want to be turned down as a criminal when I'm not a criminal now. What do I do? Exactly what are the steps, and which remedy should I pick?
Okay, so a good question and good scenario. So what I would say is this. Whether you qualify for sealing or expungement or some mix of both depends on if you were convicted of a crime or not. If you were convicted, then you would need to seal that crime. If you were only arrested and the case is ultimately dismissed or finding you not guilty, you'd be eligible for expungement. There are some details that can get a little tricky with that, but that in large strokes is what the law is in that area. There are 4 exceptions to it for conviction types you can have that cannot be sealed. So if you've been convicted, not just charged, but convicted of domestic battery, animal cruelty, DUI, or sexual assault, those convictions can't be sealed at all, and so for that you'd need a pardon from the governor. But for anything else, which includes a wide variety of even fairly serious charges, you're eligible for sealing, which means that you can file a sealing case to get that off your record.
What happens when you come to you and you file these papers? Then what happens?
So once they're filed, the process here in Chicago has actually changed somewhat recently. So it used to be that if you filed a sealing or expungement case or retained an attorney like myself to do that for you, you'd be given a court date on the spot. But that system got very backed up. So now the way it works is within 60 days of the day you file, you will find out, or your attorney will find out, whether there is an objection in your case from the state's attorney's office or not.
Do they object normally? When
Actu-
do they object?
Normally, I would say in the majority of cases, they do not object, in which case you do not need to go to court. An order will be mailed to you by the clerk's office, signed by the judge, stamped by the clerk, and you're done.
How do I know if they've objected?
You'll get a letter in the mail notifying you of that, or if you have an attorney, the attorney will get a letter. If there is an objection, then you will have a court date scheduled. It doesn't mean that your case is lost, it just means the judge has to decide it after hearing.
What kinds of cases give rise to objections?
So it's kind of things that you might expect if you think about it. More recent cases obviously are under more scrutiny. More serious cases, so crimes of violence, especially domestic violence, even if it's dismissed, domestic battery cases tend to be taken seriously. And then also sometimes crimes that implicate your honesty, because they might be concerned that you might be lying as part of this case. So theft sometimes, I would say more often something that's like a fraud or deception like that, that sometimes raises eyebrows too.
Does the person who brought the original charge to the government's attention, do they come to the hearing? Are they involved? Are they notified? What?
Not normally. They wouldn't ordinarily be notified unless the state's attorney's office makes some sort of special effort to have that happen. I've only seen that a handful of times in my probably almost 10 years of doing this. That would be more something if you had the sort of crime that made it into a newspaper, they might do that, but for the ordinary course of events, the victim or alleged victim of any arrest isn't usually notified. So the only person that's likely to be in court opposing you, if you have an objection, is the state's attorney, so a prosecutor.
And then what happens? Who's the judge? Where is this? And what happens? What are those proceedings like?
So
Am I supposed to bring in witnesses? What do I do?
So if you were to retain me or another attorney, they might talk with you about this. But here in Chicago, expungement and sealing cases are heard in the Layton Criminal Courthouse. That's 26th in California. If you have a case that's elsewhere in Illinois or Cook County, it would be in the same court that your case was originally heard in. But Chicago, it's always 26th in Cal. And then there, yes, if there's an objection, it is common to bring in character witnesses or even signed character letters are accepted. Often employment verification or educational credentials, so degrees or certificates that you've completed so that show that you would be, but for this criminal record, a good fit for working in your chosen field. Those are often used. And then also sometimes the judge might ask for other specific things, so an employment offer if you have one pending. Sometimes in certain cases you need to include a drug test showing that you're currently clean. Other documents, basically to support your case for why you should get this sealed over the state's objection.
And then what are the contexts in which it's helpful to get it sealed versus expunged?
If you're eligible to get it expunged, it's always worth asking for that. But often, if it's a conviction, you don't have any choice, so you have to get it sealed. But for most people, there's not really a whole lot of difference between expunged and sealed because for ordinary criminal background checks, it'll come up the same difference. Again, sealed just means law enforcement retains their copy, so unless you're looking to work for law enforcement or you get arrested again, for the most part, with certain detailed exceptions, especially regarding health care, sealing or expungement are the same difference for most people.
Are these cases really hard? I mean, is this an uphill battle if I'm the person?
I would say not, and again, that's because the majority of cases filed do not receive an objection. The difficulty is filling out the paperwork correctly. As a non-lawyer, it can be difficult to do because you have to know a lot of stuff about what's conviction, what's not, what kind of cases qualify. There are certain waiting periods for things. But once you're filed, most people don't have an objection, and of the objections, many of those still get granted anyway.
So tell me again where I go and what hours I can go to get some help?
So if you want to contact our agency, Chicago Legal Clinic, you can call the number on the screen behind us. We're open Monday through Friday, 9 to 5, and just tell the intake staff that answer the call that you're looking to do an expungement or sealing case. That'll get the process started with us. Apart from that, there actually is a very good help desk run by a different legal aid agency called Cabrini Green Legal Aid. They operate inside the Daly Center on the 10th floor, room 1006. Their hours are a little bit limited, but they're Monday through Wednesday, 9 to noon, and then Thursday, I believe they used to have afternoon hours as well, but I've heard that those might have been cut back, so it might only be 9 to noon then, and they're closed on Fridays. But they can provide free drafting assistance for you to help you get a case filed. You won't get an attorney in court from that, but you can at least get your case filed there, or they can get you on the right track for how to get that done.
I know that there's been a lot of press about marijuana laws changing. Well, how have they actually changed?
So that's a good question. This is a big area of change for criminal records field. So cannabis is set to be legalized in Illinois on January 1st of 2020.
But not for immigration purposes, so
Yes.
don't get carried away.
Know that for criminal records purposes, one of the sort of side effects of that is that various cannabis-related convictions are going to be automatically expunged. So the good news is that is automatic, as I said. So the process, at least, is supposed to be that anybody that has a cannabis case where it was 30 grams or less possession only, so not manufacture and delivery, just possession and only less than 30 grams, will automatically have that case expunged.
How will I know that it's been expunged? I mean, I've moved 5 times since I was a college kid and got this conviction.
So it's a very good question to which there's not a lot of great answers. So the state has retained the services of a not-for-profit based out of California that has a technology that they're going to use to basically feed in Illinois' criminal database to find all the cases that qualify for that 30 gram or less cannabis possession, single them out, and basically prepare orders for those cases to be expunged.
So if I was in school in Iowa and it doesn't help, and I was convicted there, it doesn't help me. So I have to, my conviction has to be in
It
Illinois.
needs to be in the state of Illinois, but if that is the case, then it should automatically happen. That said, because exactly what you mentioned, that a lot of these records are going to be old, there's not going to be good ways for anyone to know if this has happened for them, so it would make sense to contact an attorney like our agency to follow up and see if that's happened. Additionally, because it's only 30 grams or less of possession, a lot of people may be unsure exactly what they're convicted of. So it could be that you had too much marijuana in your possession and that's your conviction. It could be that it was manufacture and delivery, and then that would block you. It could be that there was some other case attached to this one, like say a resisting arrest or something like that, that could block you. So there are a lot of different things that might make sense if you think you might be in this boat to follow up with an attorney to see where you're at in the process. Also, I'll just say it may make sense if you're looking to do, apply for work sooner than later to contact an attorney to see if you can get this sped up a little bit, because no one knows exactly how long this automatic process is going to take.
Is this law in effect now, or is it to come into effect?
So it's been passed and signed by the governor, so it is locked and loaded, but it's not in effect until January 1st yet. Now that said, because I do work in this field every week I'm in court doing this, I do know that the court system is already gearing up to handle this influx of new automatic expungement cases. So some work is already being done to try to get everything ready. People that have cannabis convictions on their record that technically can't be expunged yet are already getting, things just continued just into January so they can get it done sooner than later without having to refile or have other delay.
Well, that is absolutely very interesting information, and I'm sure very useful information. I wish we had more time to talk about this and to talk about the many different changes, but Drew is with our agency, and you're welcome to call him. So that just about wraps it up for this issue of immigration issues. So tune in next month, third Wednesday of every month. We'll be here, and next week I'm going to have a guest who deals with domestic violence. So that's another very important topic. So tune us in next month, third Wednesday of the month. Thank you very much for watching us, and it was a pleasure to be here with you.